very much. This roundtable, conducted by the Committee on General Governmental Operations and Cultural Affairs, will now come to order. Notice of this roundtable hearing to discuss Bills 22432 and 24632 was disseminated to local media outlets via electronic format on April the 22nd, with a second notice provided on April the 27th. Notice of the hearing was also made known on the Guam Legislative website. The two bills that we are attempting to try to reconcile are Bills 224-32, introduced by Senator Ada and Respicio, an act to amend Article 9 and Article 12 of Chapter 5, Title 5, the Guam Code Annotated, relative to clarifying legal and contractual remedies to Guam procurement law, and Bill 246, again introduced by Senators Ada and Respicio, an act to amend sections of Article 3 of Chapter 5, Title 5, Guam Code Annotated, relative to source selection and contract formation in Guam procurement law. First, I want to thank everybody that's here. We had a previous public hearing about 6 weeks ago, and everybody provided testimony at that time. It was fairly evident at that time that we weren't all on the same page, as it were, and everybody was very gracious about being willing to come back for this roundtable to see if we could iron out the differences. All members at the table provided additional comments, which were disseminated to everybody else that was at the table, hoping to get everybody to understand where everybody was coming from, and hoping that with that kind of transparency, we might be able to find a resolution to these two bills. What I'd like to do is I'd like the author to be the first one to speak today. He has read all of the testimony and the supplemental testimony that all of you provided, and I believe he and his office may have some resolution, or at least some suggestions incorporating some of your suggestions. All of you that have submitted testimony and believe that any of your testimony was not included in what the sponsor is considering as his recommendation to the committee for the write-up, can, when you're called, interject and speak about whatever other amendments you think are necessary in order for you to feel comfortable. I want to thank Senator Ada and his staff for all the work that they've done on this, and hopefully after the discussion today that we will come closer to some kind of amendment that we can take to the floor of the legislature. But again, first I just wanted to thank all of you. I know you all have all kinds of other things to do, but I was very grateful for the fact that you all did provide supplemental testimony and reviewed each other's comments in trying to address the issues that are before us. And so I'll recognize Senator Abbott to take the lead in this discussion this afternoon.
Thank you, Mr. Chairman. We have two bills today to discuss and close the gap on where ideas, thinkings kind of exist. But I would like to suggest that we start with Bill 224-32. Now, you do have a copy in your packet, but since there's been an update to this, there's another version. It's called As Substituted and As Further Substituted by the author, and that's being printed right now. This latest version actually incorporates a recent a supplement to the testimony that was provided by the AG's office, and so we took those comments and incorporated where I guess for the most part incorporated it into Bill 224, and with the exception of maybe a couple of items. All right, and so a bill.
Sense in saving.
Yeah. And so the, the, the version before this, I believe, was actually disseminated to everyone, and everybody hopefully would have had a chance to look at that. And so the most recent one um, had had some changes to it, and we have highlighted it so that you see where the changes were made. Um, so, Mr. Chairman, with that, I would suggest that if we want, we maybe should go section by section, um, and and um, and if anyone has any particular issues with a specific section, we can then bring it up at that time. Um, and then hopefully we will, as a minimum, complete discussions on Bill 224. And at a minimum, we'll have that bill ready to be put on the session agenda should the committee report it out. If we still have time available, we can then go to Bill 246 and take a look at the changes that have been incorporated in that bill based on the testimony that was provided at the public hearing previously. So, they're still copying. Okay, maybe for the record then, if we can just go around the table and just identify then who is here. I know that we got a sign-up sheet, so we'll start with yourself. Press the button.
Thank you, Senator. Franklin Kupners, representing the Office of Public Accountability.
Good afternoon. Anthony Camacho, representing and on behalf of the Office of Public Accountability.
John Brown, I'm here by my lonesome.
Andrew Perez, counsel for the Guam Department of Education.
Rebecca Perez, also counsel for Guam Department of Education, and we have with us the Acting Supply Management Administrator, Carmen Deichmann.
Patrick Mason from the Office of the Attorney General.
Deborah Rivera, Assistant Attorney General.
Robert Colon,
Claudia Claudia Kinnison.
Okay. And we have with us Senator Frank Uggan, and of course, the staff that's here assisting me is Bucky Brennan. Okay, we just have to wait until. While we're waiting for the newly revised version, does anybody have any questions in general that they would want to raise at this time?
One of the biggest revisions that at least the OPA feels is necessary for both bills, overarching, is the need to have a contemporaneous amendment to the procurement regulations that are affected by whatever amendments are actually passed. I know that that job normally falls under the Procurement Policy Office. However, historically, I don't think they've passed one regulation. Our procurement regulations date back to, I believe, the actual passage of the procurement law itself, at least back as far as the 80s or the early 90s. And essentially, when they enacted Guam's procurement law, they simultaneously enacted the set of procurement regulations, which really haven't been updated except once that I can think of, with the increase in the small purchase amount, but that was back in the late 90s. So, and that was amended through a bill that was put forward by then Chief Procurement Officer, I forget, Santiago, Ricardo Santiago, I believe. And the legislature basically passed that as a bill. In like manner, we could follow that precedent, and basically, as we have the amendments to the proposed laws, have simultaneous amendments to the proposed regulations that are affected. These are sweeping changes that are being proposed. Some of them are very much needed, but without the simultaneous amendment to the procurement regulations, we basically, the big threat is if we pass a law without passing a contemporaneous amendment to the regulation, our regulations will be in great conflict with these proposed amendments.
And I guess in that case, my understanding has always been that when there's a conflict between the law and the regulations, the law, of course, prevails. And we did recognize that when we were developing the bill.
purpose of Guam's procurement regulations is they go into greater detail as to how to effectuate the statute. And further, at least for the OPA, I would say almost half of our appeals are filed by lay people, people who are not represented by counsel. And they also go through the procurement regulations as well. So by making the changes simultaneous, you show how these new, we have an opportunity to show how these new changes should be enforced and should be put into effect through the regulations. The OPA has taken one step forward, at least with Bill 224-32, and we haven't been able to disseminate this, but we did recommend some changes to the statute. We put those in, but we also included for each of the sections and each of the statutes cited in Bill 224, we also include here changes to the regulation that's affected thereby. So we've kind of crossed that T, at least for Bill 224. We didn't have time to do it for Bill 246, but Senator Ed is right that that was a very time-oriented, or it's very it takes a lot of time to do that. But I'm willing to provide this some digits after this hearing.
I think aside from the fact that just the amendments to the regulations is going to be very time consuming, I think the bigger concern is that when this bill gets on the floor, there may be further amendments made to it, and so to make regulations now based on what was introduced, by the time that the statute gets passed, may further require the changes to the regulations. So I know that the thinking was we need to get the statutes in place first, and then we know what's there to be able to shape the regulations. Attorney Brown.
Yeah, just we had a bit of history in the procurement law. 16124 was the beginning of our procurement law, and that bill was enacted in 1983, at the end of 1983, to take effect in October of 1984, to give enough time to write the regulations, and the policy office did come together and promulgate the regulations. Ricky signed off on them as an EO, even though he doesn't have the authority to do that. And so it was recognized that there were going to have to be regulations, even though they could have simply adopted the model code regulations, because they were adopting the model code pretty much as well. So I think that you mentioned changing the effective date of the bill will give us an opportunity to do that. Now, you could give authority to Office of Public Accountability, to the Attorney General's office, GSA even, to write regulations, and take that authority away from the policy office, which doesn't seem to be a very good model. Alternatively, we could have new legislation that remodels the policy office. The model code regulations commentary
conform to the law, and where there's areas in the law that need to be filled in, to fill those areas in as regulations do. So I think it might be rather difficult to go ahead and just follow the law without having any regulations of the how the specific things that need to be done exactly. I think that's what the regulations are for. The agency looks at it and says, okay, this is how we do this that's in the law. So I kind of agree with both Tony and John that we probably need some regulations. And to just time to I agree with John. It's just a question of time, the time frame in which this comes into play. That
I guess one of the questions I have is, do we need to reinvent the wheel as it applies to the regulations? Or, as Attorney Camacho had alluded to, he already took a look at some components of the regulations and based on your initial version, had made recommendations for changes that would be consistent with the proposal. So that's one of my questions. I mean, do we have to go back to the drawing board and say, okay, we're going to take this entire book of regulations and throw it out the window and we're just saying it's going to take us another 10 to 12 months to formulate something?
We wouldn't have to start from the beginning. Most of the regulations are pretty good. They fairly track the existing procurement laws as stated. Now, it didn't really take that much time. We're talking less than 30 days to actually just amend regulations, figure out which amendments or which regulations are affected by a change in the statute, and make the amendments so that they're mirrored, or they at least track the changes. Okay, and of course, this is from the OPA's perspective. I'm quite certain if the same group looked at them, they would have other changes as well. But you have a better product the more minds and more agencies that you put into it. Okay, so it wouldn't take that long, and it would be limited essentially to whatever regulations would be affected. One caution I would give you, though, discussing who should do this, historically, I'm speaking also as probably, I was a member of the very last Procurement Appeals Board, and the only one that ever found a quorum in its entire history. But briefly, we didn't hear one case. It's kind of dangerous to give these great big tasks to a special entity that doesn't have funding, that doesn't have any employees. They basically are appointees with no budget. So it would be better, essentially, to give it to an existing agency that has an existing budget to at least come up with the draft regulations. And of course, through the administrative adjudication law, there would be a public hearing, there would be legislative involvement in passing and there would be the opportunity for the other agencies to comment, whichever agency is chosen to draft these.
Chairman, I think certainly the points that have been raised about the issue of effective date, taking a look at the Procurement Policy Council, and then basically assigning the responsibility for the development of the regulations to mirror the amended statute. I think that's an issue that we can work on between now and the time that this bill gets on the agenda, so that we can input it accordingly into the bill. But given, so take note of that, and I would like to suggest then that at this point we can just go through the latest version of Bill 224, which shows there Bill 224 as substituted by the author and amended further by the author. If you look in that, basically the most recent changes made, from the previous bill that was disseminated are shown there with comment boxes. So, for example, then on the section 1 on findings and intent, we'll find there the addition of the language with respect to page 1, 3, 2, 5, yeah. Maybe we can just take a brief recess until that comes out. Okay. Sorry about that. Yeah.
I do have one comment to make on the section 1, though. There's a language that states that however, it's on page 2, starts at line 14 if you have it. However, the legislature is aware that
Is your mic on? Go ahead, turn on.
Yes. It says that, however, the legislature is aware that the court and the public auditor have rendered decisions that have refused to apply the automatic stay of a contract which was awarded prior to a protest, which is otherwise timely. They do cite Guam Imaging Consultants versus GMH. That's a Supreme Court case. It's not an OPA case. And they cite in the appeal of Guam Publications, Inc., that's OPA-PA-08-00. We take issue with that because we weren't refusing to apply the automatic stay. The issue in that case didn't have anything to do with the automatic stay. That language is more or less in dicta, and it was whether or not we were going to allow a successful protester who succeeded on appeal to get their costs. And that language has been much maligned by various attorneys over the various cases we've had, but it doesn't quite say that. And it doesn't really have to do with the application of an automatic stay, just whether or not somebody should, or a successful protester should be awarded their costs. So in subsequent appeals, the correct one cited there, in the appeal of JMI Edison, where the OPA took on the issue of whether or not the automatic stay applies between the time the decision is issued at the agency level and the time to file an appeal to the OPA expires. We found in JMI Edison, of course, that the automatic stay does apply throughout that entire period until the period to file your appeal is expired. So, and that is the OPA's official position, but that's the first time we had that issue squarely on point, and that's really the first decision that the OPA has ruled on that issue. So we request that the language at least bear that amendment and not cite the Guam Publications case simply because it's not about the automatic stay. It's a different section. However, it has been used by various attorneys to they've tried to interpret it very broadly to give it the effect they were arguing.
On that? And that was the on page 2, the second.
Yeah, page 2, starting with line 15. You can omit the public auditor and the Guam Imaging Consultants case, and we would be, excuse me, in the appeal of Guam Publications case, and we would be satisfied with that amendment or that deletion.
Quite frankly, in Bill 224, there's 3 pages of preamble here, the legislative findings and intent. And the section 1 really just kind of gives some background information, but has no force and effect. So even if we were to cut out section 1, it really does not impair the rest of the bill. And the legislature has done that on occasions when it found that we never got past page 1 to get to actually to the meat of the thing. So, but we'll take that under advisement about updating that legislative finding, the second one there, and so that we can then move on. Anybody else on section 1 on the legislative findings and intent? And we're working off of the older version of Bill 224. I really apologize for mix-up. Let's just take a brief recess. shows in color the new changes, the additional changes that were made to the second version. So, okay, all right, okay, all right. So, okay,
Yeah, just this is that one change is one that the OPA would agree with. It does conflict though with current language in the regulations. 2 GAR Division 4, Chapter 9, Section 9101, subsection C1 states that a protest is considered final when it's received by the Chief Procurement Officer, Director of Public Works, or the head of a purchasing agency. However, this bill does actually create the correct the existing practice, which is that the actual practice is that the protest is considered filed when it's received by the purchasing agency, whichever one it is, as pointed out, either whether it be GSA or the port, for example, and not the director or head of the agency. But the OPA would recommend that this actually be placed as an amendment to 2 GAR Division 4, Chapter 9, Section 9101C1 instead of the statute. That's just our recommendation, but we do agree with it as stated.
any comments? To GAR what?
Division 4, Chapter 9, Section 9101C, subsection, or 9101C1.
Okay. And then we go down to in defining who can protest. How do we define who's a person that's aggrieved? And so on line 18 there, we add the language, a person may reasonably be aggrieved if, and you have 1 and 2 there, which provides the definition of who's an aggrieved person. One who believes that that the method of source selection, the solicitation, or the award of a contract may be contrary to law, or a person may be aggrieved if there's a reasonable likelihood based on information available at the time of protest during the pre-submission or pre-opening period that such person would have been in a competitive position to be awarded the contract. And thirdly, notwithstanding such person's competitive position, the protest of such person raises issues significant to the procurement system or its integrity. I believe in the case of the Attorney General's office, they were suggesting that an aggrieved person be defined simply by using the economic test as to whether that individual was going to be substantially harmed. I think that the definition that we give here provides for that, but also provides for a little bit more as to who might be aggrieved. Anybody want to add to that discussion?
I
know there's been discussions about trying to figure out how to narrow or at least limit the number of people who can protest and define who those people are. And I'm just wondering how your office feels about these. These are three completely new definitions than what was in the.
Well, we feel they're entirely unnecessary, and here's why. So currently, as the law and the regulations stand, okay, for a procurement protest, only an actual prospective bidder or offerer or a contractor who may be aggrieved in connection with the method of source selection, solicitation, or award of a contract may file a protest. And you'll find that in 5 GCA section 5425A, and of course 2 GAR Division 4 Chapter 9 section 9101A1A. Now the term prospective bidder, contractor, and offeror is also defined, and it's defined by 5 GCA section 5480E as a bidder, contractor, or offeror who will actually submit a bid, a contract, or otherwise offer his or her services if their protest prevails. So these are very specific definitions. The party filing such a protest does have an economic stake in the outcome. However, the proposed amendment as written does seek to broaden this category by incorporating persons who raise issues significant to the procurement system or its integrity, whether or not they are actual or prospective bidders, offerers, or contractors, and whether or not they're aggrieved by a method of source selection, solicitation, or award of a contract. We feel at the OPA that broadening the category of persons who can file protests will not promote the integrity of the procurement system, will actually threaten the government's ability to carry out the solicitation process in a timely manner because it would prevent persons who are not engaged in the solicitation process to protest and enact the provisions of the automatic stay until such protests achieve their final resolution. And that's why we feel that broadening the category at least to people who don't have an economic stake in the outcome, as already defined in the procurement law, actually threatens the procurement system itself. Additionally, the other problem we have with the second section is defining when a person is aggrieved to the extent that you do here, or at what stage they may be aggrieved is also unnecessary. Currently, 2 GAR Division 4 Chapter 9 Section 9101C2 already allows a protest to be filed in any phase of the solicitation or award, including but not limited to specifications preparation, bid solicitation, award, or disclosure of information marked confidential in the bid or offer. In contrast, as written, the proposed amendments to 5 GCA section 5425A2 may actually limit protests to the pre-submission or pre-periods only, instead of that broad category of when you can file a protest that exists today. It's the OPA's recommendation that, excuse me. So we find that for those reasons, Section 2 should be deleted because they're kind of unnecessary with the existing regulations. They have the effect of broadening the categories, and they're actually very limiting as to when you can file a protest.
If I can just try to explain something here. A person who is aggrieved, who is able to protest, is only put in, and J&G had clearly been outbid in price and was not the low bidder and had no competitive standing to be awarded the contract based on any protest that was brought out. But it turned out that once the contract was awarded, the quantities were changed significantly in the contract, the terms of the contract were modified, and the price was increased by 25% over what was in the specifications. Now, J&G would not have been able to bring a protest about that had it been defined as having or needing to have an economic interest, because it was not the low bidder. It was just not the low bidder at all. And that would have gone unreported and unrectified. And the OPA did rectify it by terminating the contract. It was of that egregious effect on the integrity of the procurement system. So having an economic interest alone does not always serve the prophylactic interests of the procurement protest system. Having this competitive position is what the economic interest test is all about. The economic interest test, which is a federal standard used in federal contracts for determining the right to protest, because they don't use the word aggrieved, has to do with, are you close enough in the ranking that if your protest is sustained, you will actually be in a good chance to the high likelihood of receiving the bid or the award. And that's what we've added here. We've yielded to the concerns about having an economic interest by saying that's one of the tests, but that's not the only test. If it's the only test, you will never get to the case where a complete reworking of the award is discovered, and it shouldn't have been awarded that way, because you can protest the solicitation or the award of a contract. So I don't believe that this expands dramatically any of the existing applications of the rules and precedents, if you will, that we have in this field. It elucidates it. It doesn't expand it.
Well, if we're trying to streamline these things and narrow the parameters of protests and appeals, then I think this greatly expands it. I think there should be an economic interest, simply because, I mean, those are the people who are affected. You have to, John has said, well, they did something later that was wrong. Do you want to open it up to every offer or every bidder, everybody? You know, I just think it's very expansive. It's not a limited expansion. I think it's a very broad expansion.
The economic interest test is in the competitive position. You have a reasonable apprehension of being aggrieved and an economic interest, being in a competitive position to receive the award, the likelihood of receiving an award. Now, that's not always known. It's not known, for instance, in the case of a pre-opening bid protest. So the economic interest test doesn't decide the question who can protest a pre-opening solicitation. You need something more than that, more than the economic interest test. Granted, having a likelihood of success is an economic interest, and that's alluded to here.
Actually, but that's not the way the amendment is written. It says notwithstanding such person's competitive position. If I were a lawyer representing let's say an organization, a fanatic organization, so to speak, that for whatever reason we have our own agenda. It has nothing to do with economics, just either for religious purposes or other purposes, even nefarious purposes, anarchy, for example. I wanted to stymie a procurement of, let's say, widgets, okay? Just because my fanatical view is there shouldn't be any widgets in Gov Guam, period. Using this provision, this notwithstanding provision, having no economic interest because we're not a bidder, we're not a company, we're just an organization. I could file appeal or protest an appeal and bring it into the court system ad nauseum specifically says who can file a protest with a very broad category of when they can file the protest, I think is a much better situation than this very broad, notwithstanding language that would open it up to anybody to file a protest, whether or not they have an economic stake or not.
It doesn't give the, Section A does not give any person the right to protest. It does not give the right to protest to a nefarious organization who is not a bidder. Now, if this nefarious organization is a bidder, they might have the right to do that. But they have to be aggrieved, first of all. And how are they aggrieved? They're aggrieved by some solicitation of award contrary to law, and there's an economic interest, or notwithstanding lack of an economic interest, the protest raises significant interest to this integrity of the procurement system. It does not open the door to just any person off the street. It's not what it says.
But how about prospective bidder?
Well, are they a
How
prospective bidder? Nefarious organizations are
Well,
not
I mean,
typically.
they could have. I mean, it would seem to me that if you limited it to those who did bid,
Well,
that would narrow it. But if you did not submit a bid and you said I could have been a prospective bidder, I'm a little concerned about whether or not that's too broad. I mean, well, who is a prospective bidder? I could have possibly bid on it. So, I
Speaker,
mean,
we've had prospective and actual bidders, offerors, and contractors in the language of the law since it was first adopted and effective in October 1, 1984, and it has not presented a problem. A prospective bidder is not somebody who comes in and has no history. A prospective bidder is someone who can supply the thing and typically would. You wouldn't find a nefarious organization say, well, I'm going to somehow make automobiles and bid an automobile. They don't do that. And anybody looking at whether that is a bona fide prospective bidder would have to judge that. But it hasn't presented a problem in the last 25, 30 years.
We currently have a situation where, because of the financial criteria, maybe none of the bidders could have or should have been considered prospective bidders because they couldn't fulfill the financial obligations or criteria. But they could have provided the product. And we're currently in a major problem with one of them in that way. And I'm hoping that these things will try to narrow it so that it doesn't become, well, I could have. I mean, I have a service that could have done it, but it's not large enough to be able to do this. I wouldn't have been qualified, but I could have been the one that could have done the mowing service throughout the island. I have one bush cutter.
Well, that person would not have been, depending on how the specifications were drawn, either responsive to the qualifications or responsible if they're not capable of doing it. And so eliminating the possibility of a prospective bidder who might want to bid on, who might want to protest that the specification solicitation has come out, it's incompatible with the law, it breaches some kind of provision of the law, or the specifications are narrowed to somebody. They haven't bid yet, but the specifications are too narrowly drawn. How do you protest that? You haven't bid yet. You don't bid until the bid submissions. You're not an actual bidder until the opening date. You should be, and you're required to protest that as soon as you know about it. So you're prospective at that point. But not just anybody can hold their hand up and say, I'm a prospective bidder, if they don't have the bona fides of being a prospective bidder. They're either non-responsive or non-responsible, or not a prospective bidder, in fact.
dissatisfaction with how the bid is being administered versus a complaint about how something perhaps they did not have an economic interest in, but how something happened that so concerned them about the process or the integrity of the system that perhaps there should be a complaint procedure, maybe directly to the OPA, that says, I was not a prospective bidder, I did not bid, I did not pick up a packet, but I saw something so flawed that I have real concerns about this. OPA, will you take a look? That's as an example. But I think that a lot of the discussion that went on here indicates that this broad definition, and when I look at it and I combine it with the automatic stay provision, it's concerning that anyone who had a complaint, even if they never picked up a packet, can now stop the process until such point in time as it's finally resolved, which could include court time. I mean, go up through a number of different, ladders about how that'll happen. And if that was the intention of this, which I understand, but if it was the intention to say that if you think there's something that is so damaging to the integrity of the process, you need to be able to complain about it, then maybe that should be a complaint, but not a protest with an automatic stay, and certainly not available to somebody who didn't even pick up a packet after the bid was awarded, and then they, file. Because if you didn't pick up a packet, whether you call it an economic test or a competitive position, why are you in this process of protest and stay being able to stop everything?
Hello. Okay, if I may, as I read this legislation and the comments going back and forth, it appears to me that the legislature is looking at perhaps enlarging the number of people who may wish to look at the overall situation. And the government is saying it causes us problems. And we had proposed at some time, and the AG's office had also, to address this issue, and that is to put in a protest bond. Because if a person is that adamant that there's a problem, why not, ensure some protection to the government?
Again, I get back to the logic here. The logic was people wanted to have an economic interest test. If that's your test, things like the reworking of the award between the time that the bids were open and the contract was made in a grossly unfair way, non-competitive to the bidders that bid on it, that would not been able to be brought out. That would not have offended the OPA so much that they should terminate the contract because it would not have been heard. And it wouldn't have been rectified. And the government would have spent a lot more money than they put a solicitation out for. So we have to have, if economic interest is going to be our lodestone, we have to have a provision that allows these significant deviations from the procurement integrity, from in your mind, in your heart, that changing the nature of the contract between the opening of the bids and the award is not right. There's got to be a way to articulate that and allow that protest to be heard when it is brought by an actual or prospective bidder, offeror, or contractor. Otherwise, that kind of stuff will go on. The awards will be made, deals will be done, and harm will be done to the taxpayer, to the purse, and to the integrity of the system. So we can take out the economic interest test, take out the competitive position, and not make that a new factor from what we have had in the past, which is aggrieved. And then we wouldn't need this other thing, because certainly a bidder who bid on a contract that was not the contract that awarded is aggrieved by awarding a different contract, even though he doesn't have economic interest to protest.
Excuse me. But the IBSS versus Xerox case that you're putting out is really not of a procurement application by DOE of the contract after the fact. So the contract in it itself and the application, as you pointed out, was not a problem. It is how DOE handled the contract by just increasing and increasing and not following the process properly.
Well, not actually. It was the award. The award that was made was for a different order of magnitude of material than was solicited. And you can protest under 5425, method of source selection, solicitation, or award. So in this case, it was the award that was wrong, and they had the right to bring this protest under it. But if that person had been thrown out because was nowhere close to the low bidder, that would never have been heard. That would have been thrown out in first instance.
We're looking as I read this, we're looking at the process. Now, the award was the application by DOE. That was incorrect, but the process was done correctly, except for whatever reason, and I do not know. We don't handle DOE. I do not know why they made that award, but the process itself and what went out was correct, as you pointed out.
But we're talking about being able to bring a protest, and you're not limited to bringing a protest on the process. You can also bring it on the award. That's part of our law from day one.
I just want to bring out 2 points. First, in terms of the complaint procedure that was suggested by DOE, one in fact exists in procurement regulations. It's actually in 2 GAR, Division 4, Chapter 9, Section 9101. It's either A or B. It's in there with it's in the same statute that creates the protest and the regulations. The difference between, of course, the complaint and the protest is there's no appeal for a complaint. There's no requirement for a decision. There is a requirement to look into it, though. But there is a complaint procedure that does, in fact, exist, albeit it's probably little known and not used at all that I can see. In fact, when people submit a complaint, it's treated just like a procurement protest. We have had at least one case where that was done. But there is a complaint procedure. You don't need to create a second one. One exists.
And if a complaint is lodged, who's the complaint placed with?
It's placed with it's always the same. It's either the chief procurement officer or the director of public works if it's a DPW procurement, or of course the head of a purchasing agency if it's one of these autonomous agencies or other entities that are independent of the executive branch. And then they're supposed to review the complaint and make some kind of response to it. But there's no, if it's denied, there's no timeline, of course, to file an appeal. It's just a complaint. And I believe it's very broad as to who could make the complaint. I don't think you necessarily have to be a prospective, or you don't have to be a bidder, offer, or contractor, prospective. But I think that that process actually already exists in procurement regulations.
But in the case of a complaint, does that, so GSA looks into it, finds out that basically concludes, let's say, yeah, you have a legitimate complaint. What happens to that?
Well, essentially all the agencies, to include GSA, are empowered with various remedial measures. They can amend they can either amend the solicitation during set periods of time. They can amend the award even, or they can nullify an award. They have that power to do so long as they take action in accordance with the law, provide the appropriate notifications to the actual parties who took part in the solicitation, and provided nobody protests within 14 days, basically they can take those actions.
I think we can probably go all afternoon on just this one section.
Yes.
So so we're going to go ahead and move on to section 2. See if there's any. Well, we were in section 2. I take it there's no more discussion on the subparagraphs of section 2? And that takes us, oh my gosh, I didn't realize section shall be treated as a bar, which basically, I guess, 14 days could probably extend longer if the circumstances warrant extending that time. So, John, maybe you can.
Yeah.
Well,
Well, it-
go ahead.
you know, the claim is made that the time limits, all time limits are jurisdictional. And if you don't make that time limit, you don't have standing to bring the action. But that is contrasted with time bars, which you should do it within that time limit. And unless you have a very bloody good excuse why you didn't do it, it is a bar. But it's not jurisdiction. It does not deprive the court of jurisdiction. It's subject to equitable estoppel. We have the nature of jurisdiction is, has the government consented to be sued? Waiver of sovereign immunity. We have a waiver of sovereign immunity in 5480. The government has consented to be sued for a protest under 5425. That being the case, we don't need another waiver of jurisdiction in 5425 when it talks about the time limits. Now, if you look into Guam law, at the Superior Court case, TRC Environmental Corporation, and decided in 2008, presiding Judge La Moreno recognized that the timing limits of the procurement law, this was a procurement case, are limitations periods which can be told on an equitable basis. And he cited to a Supreme Court case, U.S. Supreme Court case, that is Young versus the United States, 535 U.S. 43. This was a case written by Justice Scalia, a noted liberal and bleeding heart person who was interested in equitable estoppel. Not likely. And he said it is Hornbook law that limitations periods are customarily subject to equitable tolling. He relied on another Supreme Court case, Irwin versus Department of Veteran Affairs in 1990, written by another liberal bleeding heart justice, Chief Justice Rehnquist. Justice Rehnquist, in the Irwin case, canvassed the prior decisions on when a limitations period in a statute such as this is jurisdictional or a bar, a time bar subject to equitable tolling. And he noted that the cases had been inconsistent, some insisting it was jurisdictional, some otherwise. And he resolved that in favor of a holding that they're customarily subject to equitable tolling. A waiver of sovereign immunity cannot be implied but must be equivocally expressed. Once Congress has made such a waiver of sovereign immunity, we think that making the rule of equitable tolling applicable to suits against the government in the same way that is applicable to private suits amounts to little, if any, broadening of the congressional waiver. Such a principle is likely to be a realistic assessment of legislative intent as well as a practically useful principle of interpretation. We therefore hold that the same rebuttable presumption of equitable tolling applicable to suits against private defendants should also apply to suits against the United States. This has been in the law for quite a while, that these time limits are not jurisdictional.
So if that's already the law, and if John has to go to court on one of these, it sounds like he's got his arguments already. But I don't, quite frankly, when you say shall be treated as a bar, and I read that, I don't really know what you mean. I can't tell by the
Now, we
language.
can take
Now,
the language out and
if
change
I
it.
go and research all these cases, maybe I'll understand it. But I think that 14 days is the limit. Now, if it can be argued that there is some equitable tolling or there is some estoppel, but I don't think we need to write into the law something that I think is, most people, when they just read that, aren't going to understand what it means. And what you're saying is, if it is jurisdictional, you can still argue equitable tolling, and you can still argue estoppel. So, if that's the case, what's the point in changing it?
The point is several one or the other. And that's what the court says. And we can change the law to say time bar. We can just say it's subject to equitable tolling instead of saying it's a time bar. That would fix that problem of ambiguity. The reason why it is in there is because many of the lawyers around this table representing the government believe that it is jurisdictional. That is, government hasn't waived its sovereign immunity, therefore it's a case of jurisdiction, and it is what it is. The U.S. Supreme Court doesn't say that. Chief Justice Presiding Judge LaMorena didn't say that. I don't think that is the case, and I don't need to have to go to court to argue with you over whether it is or it isn't. I think that it's established.
Well, you still have to establish a waiver, or you still have to establish your concepts anyway. I think we set the timelines here. We're here again. We're trying to broaden things as broad as we can get them, and I think you should just have your timelines and leave your timelines the way they are. And if you want to go before the OPA and argue equitable estoppel, fine, do it. But I think the timeline should be set. I mean, the problem mostly is this takes forever and the procurement has stayed. Now here again, we're broadening things, and I didn't think that was the intent. So I think you should just leave the timelines the way they are.
Well, I just want to add that TRC environmental versus, trying to remember, actually it was versus the Guam Power Authority. I was actually the attorney in that case representing the Guam Power Authority, and that's where we appealed a decision by the OPA adverse to GPA successfully. I believe that's in dicta, that part of the decision where the court was considering TRC's argument that the OPA had jurisdiction. Of course, that's not the direction that decision went. They found that the appellant in that case at the OPA level had actually filed their appeal in excess of the 15 days, and I think they were arguing equitable tolling, but the court shot them down and said that the OPA had no jurisdiction after the expiration of that 15-day period of filing an appeal. That was the actual ruling.
That's right, and that speaks to my point.
And as to the way the statute is set up now, it is jurisdictional essentially, both at the OPA level and at the court level. Of course, at the OPA level, the OPA is constrained. We cannot hear matters that are not properly before us, and that TRC case exemplifies that essentially. If an appeal is not filed within 15 days of the OPA after the decision, the OPA does not have the jurisdiction to hear it, period. So that's jurisdictional at the OPA's level. Likewise, 5 GCA section 5480 clearly states that the waiver of sovereign immunity has to be strictly followed, and essentially if the appellant fails to file within 14 days essentially after the decision, the court lacks jurisdiction to hear that case. So I believe it should remain jurisdictional, and it shouldn't be broadened in the manner that's being proposed here. Thank you.
Right. Tony's absolutely spot on when he says that the court found that there was no equitable tolling in that case. That the finding was that it is subject to equitable tolling, and there was no finding of the equity that requires a waiver or the tolling of the statute in that case. And that's what the U.S. Supreme Court said also. I mean, Justice Rehnquist made the point that federal courts have typically extended equitable relief only sparingly. This is not an open door. This is not a door that anybody can just run through. It is rarely enforced, but it is there. It is available. It is there for when claimants have been duped, tricked, or in good faith, with circumstances way beyond their capability to control, they weren't able to meet the deadline. And Justice, and in the case where he said that, I think that they set aside the protest over that because they said that it didn't meet the standards for equitable tolling. In the case with Scalia, they said that that was a case of equitable tolling, and they allowed it to happen. The fact that Judge LaMorena said that the case did not meet the one horse might be able to get through, not a whole herd. Let's not get hyperbolic about this. It's not an open door.
Yes, and this comment isn't related specifically to DOE, but I agree in the sense that with Pat, that I wasn't sure what this meant. And even with this explanation, I believe it just adds to there may be arguments that need to be made. But as an attorney, as Mr. Brown points out, who represents the government, it appears to me that procurement disputes, particularly when they might be resolved prior to getting to the OPA or further into court, they have more of a chance of being resolved when the law is clear. And we deal very often with individuals who are not represented by counsel. There are a lot of small companies out there who, quite frankly, just don't have in-house counsel or counsel at hand at any time. And if the clearer the law is, I think that leaves more room for discussion between the parties and an opportunity to resolve it because the law is clearer. And this section, I mean, I don't mean to add more. I think that it was put forth, but if Pat Mason's saying he doesn't understand it, I'm not sure that the owner of a small company will either. And if it doesn't add anything in particular to explaining the time limits, I have questions about why it needs to be there.
GSA, any comments?
I think Rebecca said it very easily. It doesn't add anything.
Shall we move on? To A, or paragraph B?
Yes.
Yeah. Section 2B.
Now, here's where we get at what John was arguing. It says there is a tolling provision. I mean, he was arguing for tolling, but there is a tolling provision that's been written in this law, and half the parties are in good faith engaged in settlement negotiations. And we wanted to at least add that there was a written agreement of the interested parties. I mean, when you engage in settlement negotiations, sometimes they go on for a long time. You draft something, you send it over, they look at it, they make changes, they send it, but you go back and forth and back and forth. And I don't think there should be any kind of tolling. I think they can negotiate within the period they have to negotiate. If it goes to the OPA, you can still negotiate. And I believe you can still present, if you reach an agreement, your agreement to the OPA, I would think. I mean, I'm not sure. We'll ask Tony. But, I mean, to me, when I negotiate a case up till the Supreme Court rules, I can negotiate a settlement. I don't need to toll anything. That 30 days to go to the Guam Supreme Court doesn't need to be tolled so I can negotiate. And I just think here again, we're just opening things up for that automatic stay, to be lengthened. And that's, to me, that's the basic problem that we're trying to get at.
OPA?
Yeah, basically, as far as at the OPA level, of course, if the parties come to some kind of an agreement and essentially they dismiss the case, we've usually accepted those dismissals. As far as the language, we also would concur with the AG's office that this is another provision that would simply cause untoward delay. In fact, if you logically look at this, settlement negotiations may or may not result in a final resolution. And of course, they could drag on with no final resolution. As written here, this would create literally, the automatic stay would be in effect, and you could go through a lengthy settlement negotiation and not come to any agreement. In contrast, if you leave the timelines the way they are, essentially by going through the appeal process with the OPA, and then subsequently if you had to go to the Superior Court, going through that process, you will get a final resolution. And as Mr. Mason pointed out, throughout the entire existing process, nothing stops the parties from negotiating as they go along. Just at the court level as well. If you reach an agreement, there could be a stipulation in order to dismiss, and there often are. So this is another provision that would just merely cause delay, untoward delay that is as well, and not likely benefit the people of Guam
page 5 on the version that says as substituted and amended further by the author.
And this language is the language recommended by the AGO?
Well, I think what we recommended that at the very least, if you're going to accept this, that there be a written agreement. But basically, we don't want the tolling part at all. That was just a suggestion if it's going to be left in there.
Any other comments? DOE? GSA?
There's a lot, but you're trying to get through the afternoon.
We're on page 2
Five.
page 5 of 23.
Okay. I know it's hard for you to believe, but we agree with the AG's office on this.
Thank you.
And if you are taking it for the record, what we would point out is that provisions that would tend to enlarge the applicable period of stay, I do believe those work against what we're trying to achieve generally, which is the more efficient and streamlined resolution of these matters. And it doesn't just affect the government agencies negatively, it affects potential awardees or people who have been awarded contracts. And to that, I don't see how tolling would add to that process.
Okay, we're going to move on. 5425C. Nothing on 5425C, 5425D, E, on 5425E, the subsequent changes, well, actually on 5425D, the subsequent change was recommended by AGO was on the notice of decision shall be furnished to the protester and any other prospective or interested party intervening actually known by the governor, by the government. So that was a change. And then 54E, basically the change there that was made, which was recommended by the Attorney General's office, was to, in the prior version, it laid the burden on the government to give its reasons for the rejection. For the rejection of the protest. The change that was made was to now place that burden on the appellant and to provide the argument as to the reasons why its protest should be accepted. All right. 5425F. Basically, this here, if when a protest is brought before the OPA, and if the OPA must disqualify himself from the hearing, then in that case, then the presiding judge of the Superior Court will be the one to appoint a hearing officer to proceed with the administrative hearing at the OPA level under the OPA rules and regulations.
Yeah, that's one that the OPA would not agree with, and the existing law basically requires the OPA to render a decision. However, there are the OPA has to render that decision, of course, in accordance with all the procurement law, to include the ethical portions, and the OPA has had to disqualify herself from some cases because there were close family members involved, and because of the language of the procurement law, it's basically the public auditor who has to render a decision on a procurement protest, for example, and nobody else. It's the OPA OPA's position that essentially, as an elected official, there's just certain things that the elected official has to do. And we feel that deciding the protests in accordance with the law is one of them, just like reviewing an audit, for example, or the other various powers that are performed by the OPA. Allowing the hearing officer or allowing the presiding judge to appoint a hearing officer to proceed with the case would be, number one, onerous. It would create more time. For example, right now, just for a judge to determine whether or not they're going to grant a motion to disqualify a judge takes quite a while, almost 3 to 6 months, for example. I can't imagine this to be a fast procedure if we're going to involve the court. What we have done in the few cases where the OPA has had a legitimate conflict with parties is we simply have issued a decision stating that there's a conflict and that the parties then proceeded directly to the court. And I believe that would be the correct procedure in the case of the OPA when there's a conflict.
The problem with that is that the procurement law sets up standards of review, and the OPA has a de novo standard of review. And if the OPA doesn't hear it, and the case has been taken straight to the court, does the court have a de novo standard of review? Don't think so. There's no decision from the public auditor that is entitled to great weight. So I think it's more appropriate that we have a hearing by someone standing in the shoes of the OPA to make that de novo review, fresh eyes, and to render an opinion that is entitled to great weight when it does, if it should go to the Superior Court afterwards. So I think that having the presiding judge of the Superior Court appointment is a reasonable alternative. Does it add time? Sure it does. Recusing the OPA adds time, but that's part of the structure that we're handed and we have to deal with.
Any final points?
Yeah, we still believe essentially that the way the law is set up, it does require the public auditor to make the decision, and of course the public auditor does have to comply with all the ethical requirements, and one of them is, if you're having one person, and that's the way the law is, literally one person, not decide a procurement protest appeal, for example. This is a small line. Inevitably, you're going to have a case where there might be a conflict because they're either related to one of the parties, so to speak, or reasonably it's a case where you want to avoid the appearance even of impropriety. And these are rare cases, fortunately. They're not, like, I can only think of, goodness, in the last 8 years or so, only about maybe 2 or 3 cases that the OPA has had to recuse itself from. But I believe that would be the correct procedure, not appointing a hearing officer, simply because it still allows for an expedited review. There's still a review of the appeal at the Superior Court level, and just without the OPA. Although not perfect, at least it does avoid that conflict from becoming an issue. That's just where we're at, because we don't, unlike other jurisdictions, we don't have for example, an administrative hearing division like most states do, where they simply hear administrative type cases for the state. That's not the way we're set up. So.
Pat, any comments on that?
The only comment I have, I think we'd have to have a lot of this explained in regulations on what the hearing officer would do, what would be the procedure. It says follow the procedures of the OPA, but that's not the OPA, that's one hearing officer. The OPA has a hearing officer. I think that there might be some regulations that would go with, if they decided to adopt it. I'm not arguing for it. I'm just saying if it were adopted. I'm not arguing against it. I'm neutral on this issue.
Move on. Okay. 5425G.
Yeah. Yeah, well,
Right.
This is the section that I was referring to earlier when we went over 5425A. This section adds the words "or performance." The original language that I'm reading from the current law says that the territory shall not proceed further with solicitation or with the award of a contract prior to resolution of a protest. This adds the phrase "or performance," and that is problematic in regard to what we had discussed earlier, which is, so now are we allowing, oh, I'm sorry, I'm so not used to being told people can't hear me, I apologize. But in the sense that you're now, if you're going to potentially broaden the base of people who may make a protest, or if you're going to allow somebody who wasn't a bidder, or right down to the most basic thing, where you now have a contract between two parties that is being performed, a vendor and the government, and you are going to allow someone else to intervene and complain about that, that kind of generally goes against the whole, who gets to complain about performance? And I believe there had been some earlier reference to, well, that's an issue of contract performance or contract breach, and it's covered under 5246 or 7, I believe, in the law. But I think this does really present a problem when you get to the possibility that somebody who's not a party to the contract can make a protest as opposed to a complaint and put a stay in effect.
I think this particular amendment that was being suggested here addresses the case of, I believe it was DOE. I forget exactly which case it was, but it was a case where in the morning DOE issued the notice of intent to award. Before the end of the day, it issued a notice of award. And so obviously the 15 days or whatever, 14 days, was not given to any prospective bidder to file a protest. And so what happened was then I guess the one that was awarded the contract went ahead and started performing, and by the time this thing got sorted out, the water was under the bridge already.
And I think in that scenario, if that, and well, we're the only actual government agency here, right? But in that scenario, if that's what you're trying to address, I don't think that this language does it. I think it's overly broad. Because if what you're trying to say is 15 days from the time a contract is executed, either the performance is stayed for the 15, you must file it within 15 days, then that needs to be put in there. Because what happens in the scenario when information came to light 6 months after the contract has started, or a year after the contract has started if it's a multi-year contract? This would allow a stay at that point when it's maybe a complaint about something that happened 6 months or a year ago. So if that was the intent, and there's no doubt that that scenario has come up, it's been played up in the news to a great extent with agencies other than DOE. Great many lawyers who are arguing or recently argued that issue for another agency. But I think that if the point is to say that the concern is, and what the law is trying to prevent, is that if a contract was very recently executed, that there needs to be a period of time when you can lodge a complaint about that award, then it should be specifically laid out. Give a time limit for it.
Would it be better to have a rule that a department or a board can announce that award is to be given and allow for a lag time of 14 days before the contract is signed, to allow time for people to protest, rather than meet in the morning and announce that the board has made a decision to award it to X, sign the award, the contract at noon, and it doesn't make it into 4 o'clock that afternoon and people start running down at 4:45 to file a protest, by that time it's an award already, as opposed to I mean, it's a contract going to be performed as opposed to being an award that can and should have some time for interested parties, interested aggrieved parties to, before execution. But just announce it. We're giving the board has announced that this award's going to be, this bid is going to be given to Company X in 15 days. And anybody who wants to protest, this is your time to say something. We're not going to sign the contract this afternoon at noon or in 15 minutes, and then you have no time in which to protest it.
Well, and I mean, I think it's clear from the cases that have made its way through the OPA, through agencies, through the media, and through the court at this point that there were multiple interpretations about the law as it is written. And if the objective is to say that we want to make sure there's a period of time by which we will know finally when a protest may be made, then that is one solution. To say that, well, when this announcement went out, you hit 14 days, and that's final. But I think the concern is with leaving this language in without time limits in an effort to address what may have been something in the previous law that could have been interpreted in multiple fashions, that it unfortunately does what we're trying to prevent, which is, again, broaden the scope of a stay, which will end up lagging in any scenario if it's open to somebody protesting and putting an automatic stay at any time. So that, I think, is one example of how that might be done. But what I'm recommending here, without getting into actual specific language, is consideration of clear and concrete methodologies or timelines. And I don't think that's done by adding just the phrase or performance.
Yes, thank you. I think that that's a reasonable approach to getting at the things that have been given rise to this kind of issue, and the OPA ruling that came out, so you didn't have time to even appeal, and that's why they said we're going to stay the performance, unless I'm reading something into it that isn't there. Those are the cases I think we'd be most concerned about here. There is another case, though, and I go back to that one where the contract was rewritten. We didn't get a copy of that contract, notwithstanding a lot of effort to get it, for a couple of months after the award. And so I would hope that if we get around to saying we're going to award it, and you have 15 days to protest from this notice, that it come with a copy of the contract that's going to be signed, so we can see what's going to be signed. And because the protest can be over the award, if we don't know what the award is until sometime later, it's got to stay the performance, or it's an ineffective protest. You understand?
Yes. I'm trying to figure out if there's a way that we can write something that you cannot sign a contract, award a contract that was not what was in the bid. End of sentence.
Well, that should be the law already. And
Yeah, no, I understand. But there are
additional to this, though. It would be, give us a copy of the contract that you're going to sign, and that can change.
Yeah, that wouldn't work, though, for like requests for proposals where you're supposed to negotiate a contract after, basically after the bid or after the most qualified bidder has been accepted. That would work, of course, if you had like a standard form contract for invitation for bids, where it's just the lowest bidder gets the contract. But going to this issue here, I do agree with the statements that this would actually get rid of the effect of Long Imaging Consultants case by the Supreme Court. They drew a bright line, and that bright line essentially was if you protest after the award, the automatic stay doesn't apply. If your protest comes in before the award, though, the automatic stay does apply. So it has a very profound impact in terms of what you could get as a protester. And that's where that language, or performance, it would get rid of that long-standing precedent, because it doesn't matter then if you do it before or after the award. The performance of awarded contract that's essentially a broadening that the OPA doesn't agree with because it would not be efficient. The bright line rule is there for a reason. We'd ask that the original language be maintained or the performance be taken out. We join with the rest of the organization that does so. The exact issue, though, that was brought up doesn't really concern the award. Of course, you can protest an award. It has to do, of course, with I believe the case most recently was the agency had a protest, and at about 11 a.m. or something, the agency denied the protest, and 2 or 3 hours later, the agency awarded the contract before the expiration of that 15-day period to appeal, because, of course, the agency didn't want the automatic stay to apply to the contract, and so that does need to be addressed, and I would agree that some language in there that says you would have to wait till the appeal period ran before you awarded it after denying a protest, I believe is fair. I haven't seen that in the existing provisions, but I would agree that that's something that would have to go in.
GSA?
While the ideas are good, my problem is what happens if there's an actual emergency for the government and we need to move forward? Let us say that it took a while to get ambulances out, for example, and we finally have ambulances. We're going to wait 15 days before we could start ordering it. They have a 360-day lag period. I mean, I'm just saying.
Based on the emergency authorization for the chief executive to step in and use his authority, that there are some exclusions or exceptions to the procurement provisions.
I'm assuming you're talking about emergency
Yes,
declaration, but I'm talking about just regular bids that they're talking about where we can't award immediately. We have to wait the full 15 days for the protest time period to elapse. And I'm saying there may be periods of time where there's a need for an immediate action by the government. And if we waited the full 15 days, we may already have a delay before, because we have, if for example, there was a protest, and by the time we finish the protest, finally making our due diligence on it, another couple weeks have passed, and then we're going to have to wait another 15 days where there's an urgent need by the government.
But I think even in the example that you used, the fact that there was a 360-day lag within which to build those ambulances, and we've been without them for months, 15 days would not be that detrimental to the government, because it would at least prevent a whole set of several months of litigation if everybody knew that it was going to be this kind of ambulance, as opposed the tall skinny ones as opposed to the fat ones, and how those things were being awarded. I have real problems with emergency procurement as is, because unless it was a typhoon, we've known for years that there was a problem. I mean, we've had a discussion today of a problem that's been emergency for 16 months now.
Yes. If I may, though, in regards to the 360, it's because of the manufacturing cycle.
No, I understand. So the 15 days isn't going to kill us. We've done without them for 3 years, and it's going to take another year to build them. Get it clear in those 15 days that there's not going to be an issue about the award, and if there is, then you can stay it so that you don't have the situation, well, it's already been awarded, we've already sent the purchase order to the manufacturer, it's on its way, we can't stop it, it's going to cost us 3 times more than the other ones that could have been bought, but it's done, so I just don't think that, I really have major problems with this claim of emergency.
And there also has been a few instances where, I mean, obviously we don't like the idea of adding another tier, it's an overnight or 2-day emergency that needs to be addressed, then there's always the option of the chief executive calling the legislature into session to suspend some application of particular rules and regulations. So I mean that option, I mean it's happened many times during typhoons and storms in the past, where the chief executive has identified resources. This is what we need to do. We need the authorization. I will call you into session so that you can immediately act on my proposal. So I mean there are already some safeguards in place in terms of addressing the urgency with regards to life-saving or life-threatening situations in terms of working within the rules. So that's how I
Senator, if I can add, there's a much less onerous situation that's allowed, and perhaps will take some of the wind out of the hyperbole about the stay, and it's built into our law as well. The stay can be lifted. There's a process to lift the stay within a few days. If there really is urgency, if there really is necessity, we have a built-in process in this code section that we're reading right now to lift the stay and allow the award, the performance, the solicitation to go forward.
But is there a concomitant provision that allows for the protest once it's awarded? You can lift the stay, but you can't give them back their 15 days if it's already been awarded.
Well, that's right, and it becomes a Pyrrhic victory. But the protest is not the problem, because it can be lifted. I mean, the stay is not the problem. It can be lifted. Now, whether they go on and get a protest that says, yeah, and the award was made, but it was made in violation of a lot of laws. Yes?
I'm sorry. I just wanted to say, I think what I was saying might be a bit confusing. The issue that was raised, as I understood it, was after an award, we have to wait 15 days, time period. The 2-day issue is after a protest, a declaration, blah, 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 blah. You can do that in 2 days. But for example, if there's no protest and after an award, there are times when the government actually needs the item for whatever reason immediately. In my example I'll use is, let's say we do an award for toilet paper to take and then they need it at DOC. All right, I mean we can't wait 15 days to award it.
But you should have been more diligent in making sure that you didn't wait until you completely ran out. And the thing is, you know, and also maybe 15 days is too much, but how about maybe 48 hours after you announce it so that it's out in the press, it's out in the public, and somebody can come in? Because the thing that bothers me are the ones that are decided at the board meeting at 9, the contracts are signed at 11, and nobody hears about it until the news at 6 o'clock that evening. Or 2 days later when they finally issue a press release that the contract's been awarded. It just seems to me that there has to be some kind of lag time, and maybe, admittedly, 15 days may be excessive, but some time to make sure that it's not, the OPA isn't forced to say, well, it's already been awarded anyway, and the money's been given, so let's just forget it and slap your hand and say, oh, well, bad boy, you shouldn't have done it.
And if I could respond to that one also, if we're going to change the 15 days, that's the right of appeal. Because if you're saying that you can make it the award after 2 days, you're depriving the protesters of the due process that's been given them by the law, which is a right to file an appeal within 15 days. You've eviscerated that right. It has no meaning anymore because you've awarded the contract, and you don't have any of the pre-award remedies. You're just out of luck. So if you're going to say, okay, well, you can proceed after 2 days, then let's make the filing for an appeal 2 days. And we recognize right away that that's just way too short. It needs to be consistent. There needs to be enough time to discover the facts on which to base an appeal, which you don't know until you see the award.
Well, a simple solution, actually, if you're looking at where to put that, there's for each type of solicitation, there is a provision governing award. You could have a general provision that states no award or an award that's issued after or within 15 days of a protest is voidable if an appeal is actually filed. For many of these awards, no appeal to the OPA is actually filed. I think most protests are resolved, in fact, at the agency level. We're not getting every protest, not every protest is appealed. So by stating that an award is voidable if it's appealed, I think might be sufficient compromise between both the agency's need to award and the protesters' need to have the automatic stay apply, because of course if there is an award made and it goes before the OPA like we've done in the last couple of cases, we can't actually find that the automatic stay in fact applies despite this untimely award or this suspect award, so to speak, made shortly after the protest denial.
But I do believe that the point that you made was just where in the process this time period might take place may even negate the need for a voidable award if the language, for example, were to say you must issue a notice of intent to award to all interested parties, and that is a trigger of knew or should have known, as an example. And I brought this up as an issue with my concern about the wording of performance in here, because I think it does broaden it. And again, particularly when you're dealing with individuals who are not represented by counsel who may be filing protests, the clearer the timelines are to them, and the less subject to multiple interpretation the law might be, the more likely we're going to be able to clearly resolve protests if they are filed. But I would agree, I actually, more so than having it voidable, is that if there's a requirement, if you're going to put a requirement in there, an agency has to give notice of an intent to award, that's a timeline then that we can take into account with the existing 14 days knew or should have known. But I do believe it needs to be clearly stated.
And with that notice of intent to award also comes the information, all the information that comes with the award, correct? The bid that was
Generally,
made.
yes, but I do believe that's another thing that was brought up with regard to how the regulations fill some of the holes in the statute. Because if you're going to say notice of intent to award in the statute, then the regulations could lay out this is the kind of information that needs to be included in a notice of intent to award. You could say the vendor name, you could say other bidders, or proposers. You could say, and here's a copy. There are a number of things that could be done to make that clear. But as written, it's concerning that it's too broad, particularly for an automatic stay, particularly on the issue of performance. And if you are going to put, if the law is going to state very clearly, this is what you have to do, it just asks that it state it clearly. Because the cases that have come up, I think, through the OPA and through the courts, these large media coverage cases all involve multiple interpretations. So limit the kind of interpretation that could be put into the law.
Just one final observation. The stay of performance of a contract, this is not the first time the subject matter has been heard in a law. It is the law in the feds. I'm not saying we're going to adopt the FAR or anything, but they have an automatic stay on performance of any contract, regardless of where it is in the course of the performance, when the protest is filed. It's a 100-day stay, so it doesn't go on forever, but there is a timeout to try to resolve the problems. So I'm just saying, this is not something that has never been done before.
All right, thank you. We're going to go ahead and move on to, okay, are there any other questions on 5425G, subparagraph 1, 2, yes?
Senator, I'd like just to state, also to recommend, if we're considering to indicate or to include language regarding the 15-day stay, or we must wait the 15 days, that we should also consider there was a new requirement issued by U.S. Homeland Security, where that even if we're under emergency, the state of emergency, and it exceeds, let's say, $100,000 that is needed by the territory, or let's say we have a typhoon and we need to procure anything over $100,000, which is considered small purchase to the federal government at this time, it has to be put out to a formal solicitation. In other words, with our local laws where, emergency, it doesn't matter the amount, we can actually execute an award. But with an update with the U.S. Homeland Security, they've already informed us that anything over $100,000 during a disaster has to be issued through a formal solicitation. Okay, so that's an update that was just recently provided to us.
Isn't that, Claudia, if I may, applicable to potential reimbursement requests? So let's say, for example, a natural disaster occurs, $5 million has been identified with no intention of getting reimbursement, and would that particular provision apply? I'm under the impression that it's applicable if, in fact, the government of Guam has intentions of filing for a request for reimbursements.
And that's correct if we're going to be using the federal, yes, the aids coming in. Okay, so anything 100,000 and above has to be issued through a formal solicitation.
No other questions on page 8? 5425H. It's an existing provision. Minor change. We just changed the word protestant to protester. The same throughout on page 10. The power of the public auditor to assess reasonable costs, including attorney fees. And I think, let's see, if I recall, the assessing of fees is also can be assessed against a party who files a frivolous protest.
In any action filed into a frivolous
Well, turn on your mic, please. Right. So this basically is for the guy who that I guess that example that we discussed earlier about the person who just wants to throw the monkey wrench into the works. When it comes up to the OPA can basically assess them if they find that it's a frivolous protest. And then on page 10, subparagraph 3I, sub 5425I, regarding finality, that the OPA's decision is final unless that is taken up to the Superior Court and further appeal there. Okay. We move on to section 3, 5426. Authority to debar or suspend. Any questions there? Move on to page 12. There's really not much significant changes there, except on the issue of the finding of the Department of Labor failure to pay employees engaged on the contract in violation of the wage determination. And that has to do with violation of contract provisions. So the failure to pay employees may be a cause for debarment or suspension. That's new language.
section 3, I'm sorry. When you're talking about the proposed, can we go back to 5426A? I'm sorry, there's some changes between my copy, I guess, and what was put here. Same officer consequence. Can we go down one more, please? Okay. Yeah, in reviewing this, basically, I think the department provisions are originally meant to last for 2 years, and I guess as they're originally drafted, the debarment can last for 2 years. And basically, the OPA feels that this 2-year period, which is existing, allows the government agency to suspend a contractor or gives government more options when dealing with minor procurement infractions. The existing language of it. And of course, we would also recommend basically that 5 GCA section 5426A basically be further amendment to eliminate the elaborate hearing procedures at the purchasing agency level for department or suspension. This is basically, these elaborate procedures have essentially been what we feel has prevented the government agencies from conducting any debarment actions. They're quite extensive on, I guess they track the Administrative Adjudication Act, and we also propose that the regulation, of course, be that tracks this law be amended so that after receiving a decision from a purchasing agency for debarment or suspension, a person can simply file an appeal with the public auditor should they desire a hearing. Basically, the way the statute's set up now is they're required to go through this very elaborate procedure at the agency level before the agency is permitted to debar anybody. And we feel basically that the agency should be able to just make that determination. If they disagree with it, of course they would be required to state why somebody's being debarred. And if they, the contractor disagrees with that and they really want a hearing, then of course they can file an appeal with the OPA, and they'll get their hearing. So I think that debarment in general are rare if they're done at all. And by simplifying the procedure, this might actually become an effective tool at the agency level.
I applaud the idea that this can be an effective tool. I really think it can. I think it's overlooked. I think it's underused. And the nice thing about it is that the law as written allows a petition by any member of the public to seek to have a contractor debarred or suspended, which should get a lot of people out of the letters pages of the paper and into the petitioning process to have people debarred rather than just complaining about it. I'm not sure at all, it may be the case, that you can debar somebody without a hearing. And so suggesting that the agency can just debar the person and then if they want a hearing they have to appeal that, I don't know that that's constitutional. It's an attractive proposition, but I don't know if we can do it. And if there's anything short of an elaborate AAA procedure that we could do that would satisfy the minimal due process rights, I'd be in favor of trying to put that together, but I'm not aware of one.
Okay, anything further on section 3? Yes, ma'am.
Generally about the right of appellate review, because it had been brought up by the OPA. It's completely understandable that if a potential vendor was going to be debarred from doing business with the government of Guam, that they
more than that. And so I think having these high standards kind of weed out the garden variety complaint that we might be worried about, and I don't think we need to worry about them.
I just want to clarify the example that you gave. I guess under the law right now, if let's say I was a student at DOE or at UOG, and a contractor has been awarded to provide internet services, and that contractor is just not performing. I guess under the current law, I can basically initiate proceedings to have that contractor debarred because his non-performance is affecting me. And if I understand correctly, you're suggesting that probably I shouldn't be allowed then to initiate that.
No, I agree that the petition by any member of the public, as far as mine is the appellate portion of it. It's, sorry, if the agency, the purchasing agency has reviewed it and determined there's no reason at this point to debar or suspend. If I'm reading this law correctly, then we want to give the student, in your example, equal right to go to the OPA and say they should have been debarred or suspended. Now, I understand if for the person who may potentially be debarred, there should be, that's a big deal, taking away the right to contract with the government of Guam. It's also a big deal to be able to complain about vendor performance. And if you're going to say, we think, that, again, their performance is so atrocious, you should be able to petition for debarment, do it. But are we going to continue that all the way up again to the OPA if after the purchasing agency is under an obligation to entertain that petition, to do their investigation? And they've said, we've looked at this, but we don't believe there's enough reason to debar. Because essentially what you've done is given a third non-party entity, to a contract, again, these broad rights to interfere with performance of the contract. I don't think that there should be anything prohibiting somebody from complaining and petitioning for it. I'm just wondering why we're giving them the same rights to appellate review as somebody with economic impact to their business. And there are other methodologies. If you think that government funds are being mismanaged or misspent, there are other provisions in the law that allow you to bring that forward. But it's the process that we're looking at. And again, if our overall goal is, I don't want to say narrow because I don't think that's correct, but to make more efficient and to make clear these levels of rights, these timelines, and what needs to be available, everybody should have the right to petition. I don't have an objection to that. I just don't know about the right to appellate review at the OPA level.
Just one last comment on that. The comment was made that this interferes with contracts, having the party come in and complain about the performance of a contractor, but it doesn't. The debarment and suspension is from future awards. After consultation with the Using Right Committee, they shall have authority to debar a person for cause or to suspend a person for probable cause from consideration for award of contracts. Once they have a contract, this doesn't fall within this. This doesn't stop contract performance. It stops awarding future contracts to them if that were to come to pass. Now, it may be that a government would have some interest in sweeping under the rug some contractor's performance if they're aware that they've been complicit with some of that. And so they might have reason to deny it. And if there's no appeal to OPA, we'll never know. So I think taking away the petitioner's right to appeal to OPA is just as egregious as taking away the contractor's right of appeal.
Yeah, I was just going to say that currently the way the law is stated is the only ones that have a right to appeal a debarment or suspension is the contractor who's been debarred or suspended. That's it. The issue really is the statute does allow, as it's written now, any member of the public to essentially petition the agency to debar or suspend a contractor. But let's say the agency takes no action or denies that request, the public doesn't have the right of appeal to the OPA. We recently had a case where we had to find that was the exact issue in I think it was Specific Data Systems versus DOE, where they basically we had to find that the OPA had no jurisdiction essentially to review the agency's denial of a member of the public's request to debar and suspend. So, as far as the OPA's position, our only real position is, as we've already stated, debarments or suspensions are almost not done simply because most agencies are not set up to hold the public hearing that's currently required to debar or suspend them in the first place. So that procedure should be basically made more efficient. So debarment or suspension becomes a reality. Currently, it's not.
I agree with that totally, and I think it could be expedited by just have a plain administrative review in which somebody files something, the agency makes a decision, you have a right to go to the head of that agency, and that's your due process, and have the head of the agency say, oh, we're right, we're wrong, and then an appeal from that. I mean, that would be, I think, a faster way. It's like traditional administrative law where the agency makes a decision, you say, I don't like it, I go to the head, I have the right for due process, go to the head of the agency and say this is wrong, and the agency makes a decision, and then you file an appeal. And now, of course, if it's not somebody involved in the procurement, I guess it doesn't go to the OPA, you'd have to go to court, I guess. But you would then have the right to appeal that decision. But I think that could be expedited, and I think the procedures are we're looking at one right now, and we're trying to sort the thing out, and it's complicated and time-consuming. I agree.
I'm a little bit confused on the statement that there's no right of a petitioner to appeal to the OPA. Just point out that the petitioner's right to, the member of the public's right to petition to take action to debar is under subsection F. And subsection E says a decision under subsection F of the section shall be final and inclusive unless an appeal is taken to the public auditor. So that would tell me that there is a right of appeal to the public auditor. Just reading the sections.
And I don't know that Attorney Camacho, I know the case that he's speaking of, and it had to do with, if you look at finality of decision under Section E in the current law, it says 5706. 5706 is a contract or breach of contract controversy. It's under debarment or suspension.
Not a debarment, sorry.
Yeah, it's so I think that, again, as the law is currently written, there are some references back and forth that refer to sections and that aren't necessarily in the other section. And I just wanted to point that out because Mr. Brown brought up the statute. But I also agree that the process, whether anybody considers it underutilized or potentially overutilized, it could be streamlined significantly. So I'd ask for that to be considered.
If I may, GSA debarred a number of people back in 84 or 87, about 30 some. But we had to follow the AAA process. So if we're looking at trying to change some of this, it would be nice to do so. But in regards to the issue of an individual, not a party, who wishes to appeal, I again raise the issue of a bond for the protection of the government.
Okay, I know that in my readings about the bond, I guess it kind of puts a chill on the procurement process, so I guess there's two schools of thought on that, but thank you for that. Mr. Chairman, I have 4:30 now. I don't know that we're going to be able to, we are only 50% of the way through. I don't know that we're going to be able to get through the rest of this without just, doing it the justice that it deserves. So I would suggest that we recess at this point and, subject to the call of the chairman, come back and I don't know what I was thinking when I thought we were going to be able to do 244 and 224 and 246, but
Not with this group.
yeah, I realized that after the first section.
Why do you think I tried to give it away to a different group council to do this away from here. But what I would like to do, and I think we might have been able to move this a little faster had we circulated this most recent draft. Why don't we recess for about, we have a session next week. So we'll recess, I'll send out notice after we finish session. And it'll probably be almost 2 weeks. But in the meantime, you now have the most recent draft by the author. And I know we moved through this very quickly. If you can go through it with a fine-tooth comb and make your comments, and we'll circulate it amongst ourselves again so that we understand where we're all coming from. We might be able to move it a little faster once we've all had a chance to see what the rest of this looks like. And if there's a revised 246,
Yes, Mr. Chairman, we do have. We have a revised Bill 246, and my staff will also send out a digital copy to everyone who was here today, and that'll give you ample time to take a look at it.
yeah, I think. Okay, I think it'll, in the 2 weeks, I'm hoping that you'll be able to go through your copies of 224 and 246. And when we meet again, we should be move a little faster. The standing rules don't provide for a way for this to be uploaded into the posted on the legislative website. So what I'm going to do, and I'm announcing to the public, and I will get this out, is I will post it on my website, which is www.senatorbjcruz.com. I'll post both bills, and any attorney out there who isn't here, rather than have them holler and scream after we finished, I'd like for them to be able to provide comment before we come back, and maybe even written comment. I'll contact the bar and see if they would provide notification that it's on my website, and I'll send it out to the listserv. And if they want to see it, then